started. I want to welcome you. I'm Linda Rio. I'm the Community Services Director here at the Chicago Bar, and I am thrilled to see all of you here. We've had a lot of excitement about this program. We're excited, the court's excited, and from the turnout I can tell you are too. So let's just go ahead and proceed and let you know how this is going to work. I'd like actually to first get a show of hands to see what our distribution is here of people in attendance. As you know, the panels are composed of 3 different categories. There is a matrimonial lawyer, a non-matrimonial lawyer, and a non-lawyer. So in order to help our speakers today know who they're speaking to, let me just get a show of hands. So if you are a matrimonial attorney, which means your practice is 20% or more matrimonial, could you raise your hand? Okay. If you are a non-matrimonial attorney. Okay. And if you are a non-attorney? Okay, great. We have a pretty even distribution, I think. Thank you. I first want to just thank some of the people who helped us put this together. There were a lot of them. We got a great deal of assistance from the CBA's Alternative Dispute Resolution Committee, and Lynn Gaffigan, who's the co-chair, will speak a little bit about the help that we got from them. I also wanted to introduce your trainer for next Monday, who's been incredibly helpful with this program, and that's Jack Cooley. Jack, if you want to stand up. So for Monday's program, our training will be on the how-tos of arbitration and the how-tos of arbitrating these cases. Jack will be our lead person at that. I also want to introduce 2 of the CBA staff that you'll be interacting with a lot. You may have met them coming in, but if Charlotte and Linda, you could step into the room. This is Linda Boyd Oates and Charlotte McDaniel. They are the staff people who will be working with you, scheduling these arbitrations. You should feel free to call them if you ever have any questions, but I just wanted you to get to know them and see their faces. Thank you. Let me go ahead and introduce our panel of speakers. And just so you know, these are not just people who are speaking here today. They've all been intimately involved in this program with its design, with its implementation, with putting together the materials. So these are the folks who really know what's going on here. To my immediate left is Judge Timothy Evans, who many of you know. He's the presiding judge of domestic relations, and he's introduced many innovative programs over there, including this one, and we're very happy that we're working with him on this program. Next to Judge Evans is David Pasulka. David's with David Pasulka and Associates and is a matrimonial practitioner. He's a former chair of the Matrimonial Law Committee at the CBA. He also helped us put together the materials, and he put together the sample problem that you'll be working on Monday, which is in your packet. Thank you, David. Eddie Manilis is sitting next to David. He's with the law offices of Eddie Manilis. He's the immediate past chair of the CBA Professional Fees Committee. Eddie was involved in the very early stages of this project up through the present time. He, I think more than any of us, is responsible for this program's design, and he'll be speaking today a little bit about what these cases are about and fee disputes. Thank you, Eddie. To my immediate right is Brad Ginn. Brad is the executive director of the Center for Conflict Resolution. The center will be handling the mediation piece of this program, and I know some of you are here today who will be mediating in addition to or instead of arbitrating these cases. So Brad will be speaking to us about the mediation piece. And then to Brad's right is Lynn Gaffigan. Lynn is the co-chair of the Alternative Dispute Resolution Committee here at the CBA. She has spent many hours working with me on the materials and on implementing this program, and I thank her for that. And she is also an experienced mediator, and she's going to speak a little bit to the ADR committee.
I want to talk a little bit about this being truly a joint effort. There are even more people involved in this than you see up here, a lot more, and some of them are not here today, but I want to talk a little bit about some of the additional input. Geraldine Soak Brown, who I don't believe is here today, really jumped in and wrote all the procedures for this program. And with the help of Scott Carfello, who I think is here somewhere. Scott, are you here? Will be probably later on. And you'll see him in the training on Monday. Jack Cooley has already been mentioned, but has also been helpful in putting together the procedures. Susie Schrader wrote the evaluation, the feedback form. She is the vice co-chair, I think that's the right way to say it, of the Chicago Bar Association ADR committee. And the evaluation forms are really important to us for a number of reasons. But before I go into that, I also want to thank Anita Rowe, who is here today, who is a mediator and an arbitrator. She will be assisting in the training. And Stu Whitman, who is not here today, but who is an experienced arbitrator from a very different area, but who's also going to assist with the training on Monday. This gives you an idea of how many people and how many different backgrounds are represented in this program. What's really important, I think Scott Carfello said it very well. He said, truly the success of the program, though, is in the quality of your neutrals. And so that's why I want to thank everyone for coming. It's not just the ADR committee or the people sitting up here. It's really going to be important that all of you can follow through on all this information that we've tried to pull together for you. Communication as a mediator, I would say, is going to be key. So the feedback forms that you have, there are arbitrator evaluation forms and peer evaluation forms. They're at the back of your materials. We're going to ask after every well, Brad's in charge of after mediations, but after all the arbitrations, we're going to ask that everybody fill these out for yourself, what more information you need, how the procedures are working for you, how they're not working for you, and as the parties to do the same thing, what's working for them and what didn't. Our goal is to have a really good program here. We're planning to do follow-up training. We need to know what more information you need and what's not working procedurally. Communication's also going to be important, not just in the feedback forms, but also in the communication of this to the other committees. So we're trying to put together some presentations for the Matrimonial Law Committee and also for the matrimonial judges so that you guys aren't the only ones that know the procedures that are supposed to be followed. If you have any feedback on today's training, I really want to have it. And because there are so many people involved in this, I want to say you can call Linda or you can call me at any time throughout this program. I also want to say that if you could write some of these suggestions down at the end of today's training rather than leave me a voicemail, I would really appreciate it. So if you could all just pull out a piece of paper right now and write down at the top of it, number one, are you a mediator, an arbitrator, or both in this program? What do you expect to be in this program? Some people will be both. Some people are mediators and arbitrators. Could you write down then number two, do you have experience as a mediator or an arbitrator, or both, or neither? Number three, and you'll leave a few lines after this, please write down what you liked best about the training. As you go through the next couple of hours, make some notes. I liked this. And number four, what you liked least. Leave a little more space. Number five, what additional information you need to do the job. Sure. And number six, any additional comments? With all the planning, I didn't do this form before today. So this is the result of my train ride. So number one, will you be a mediator or an arbitrator or both? Number two, what are you experienced as? Number three, what you like best about the training? Number four, what you like least? Number five, what you need more information about? And number six, anything else you want to say? Our objectives for this program really were to have a really consistent, reliable, but also high-quality program that's well integrated. And In doing so, it was also to provide, I know for the ADR committee anyway, to provide opportunities for people who really are committed to ADR and who really want some opportunities to do this. So I hope that we meet all those expectations, and if we don't, I'm sure you all will let me know about it. Thank you.
Thanks, Lynn. All right, I'm going to go over with you the logistics of this program, the rules of procedure that we set up to do this. Let me first walk you through the materials just so you know what's in there. The first thing in your materials are actually the CBA program rules of procedure. I'm going to walk through that in great detail with you. You also have, following that, the relevant court orders that you'll see in these cases. These are orders that we drafted with Judge Evans that the matrimonial judges will be entering in the cases, first sending the cases to arbitration, then actually setting a schedule, and then if need be revising the schedule if something happens. So just so you know what those will look like. You also have the agreement for binding arbitration. We included the attorney's fees provisions under the Marriage and Dissolution of Marriage Act. Included within that is the authorizing statute for this program, which is in section 508. What is it? 508 A4. You have the Illinois Supreme Court rule that governs fees in Illinois. You have David Pasulka's outline that he graciously did for us, guiding you through Illinois law on attorney's fees. You have, thankfully to the ABA for giving us permission to use this, the formal opinion that the Ethics Committee entered on professional fees issues. Then you have sample pleadings for these types of fee petition cases, which David put together and will be relevant primarily to the training on Monday. Then you have a copy of the Uniform Arbitration Act, which governs in these cases. And finally, you have the evaluation forms for this program. We'll be distributing forms both to you as arbitrators and to the parties, because as Lynn said, this is very much something we want to get feedback on, both from you and the parties, so that we can make changes that better fit with your needs and with the parties' needs. Okay. Let me give you one very long sentence summary of how the program will work, and then we'll backtrack and go through it in detail. One of the parties, usually the attorney, will have filed a petition for fees with the Domestic Relations Division. Both parties will have agreed to arbitrate the case. The court will enter the relevant orders. The parties will notify the Chicago Bar of the dates they're available and send us all of the relevant court documents. The Chicago Bar will organize a panel. That's you. The panel will read the documents that they receive from us, hold a hearing, make a decision on the award. The parties will then turn that award over to the court, which will enter it as a court order. So that's the one sentence summary of the program. Let's go through it in some detail just so that most of your questions will get answered and you'll know in advance exactly how this is working. So if you look at your rules of procedure in your materials, which is the first document, we'll start with sort of beginning the arbitration. As I mentioned, the court will have entered an order, and Judge Evans is going to sort of talk about what is occurring within that context. But the parties will then send us the order and the arbitration agreements, and they'll let us know 2 dates and times that they're available to conduct the arbitration. And then within 3 days of their next status call with the court, they'll also send us any of the relevant court papers that have been filed, the orders, the petition, any responses, the engagement agreement, and any other things that were attached to those pleadings. So once the CBA has all of that in hand, you will get a phone call from Linda or from Charlotte asking if you're available on either of those dates. Now, they'll call from each category until they have filled that category. So we'll get a matrimonial attorney, a non-matrimonial attorney, and a non-attorney to fill the panel. If you do agree to do it, you do need to be available on that day, and you need to be available within a week period thereafter in case any issues come up that need to get resolved. We are asking that the orders, for the most part, the awards get decided the day of your hearing, but that won't always happen. It may be that you need to regroup with the other arbitrators by phone, or there may be some other document you want to take a look at. So we're asking that if you do agree to a date, that you're not leaving on a 2-week vacation the day after, which would then postpone the entering of the order. So sort of think of that when Linda or Charlotte give you a call. The next thing that'll happen if you are available on that date and we get a panel together is that the CBA will notify both the parties and the panel of who each other are. And the purpose of that is that you all and the parties need to screen for conflicts. So you will find out the name of the attorney and the name of the client who is involved in the case, and similarly they will find out the name of everyone on the panel. Then everyone has 10 days to notify us if there's a problem, if there's any sort of conflict, and conflict is sort of defined broadly here. If you, obviously, in terms of your knowledge of the matrimonial attorney, many of you will know that person. That's not a conflict. The question is, do you have some interest in the case, or do you have such a tie to that person that it would be inappropriate for you to hear this case? You need to let us know that, either if you're the matrimonial attorney or if you're on the arbitration panel. If there is a conflict, we will appoint a new person to represent that category, just so that there's no potential impropriety. So once we have the panel set and there are no conflicts, we'll go ahead and confirm the date with everyone and get everyone all of the materials that they need, all of the pleadings that were filed in the case. You do need to know that during this time you shouldn't have any contact with the parties, with either the attorney or the client in this case about this case. You should just keep this case separate from any conversations you have with them. You very well may be meeting with them on other matters, but we do ask that you not discuss any of the particulars of the case with them prior to the arbitration itself. The other thing we ask is that you as the arbitrators can communicate with each other about the case, but you should only do that when all three of you are together. So you shouldn't have a communication with one arbitrator if the other is not present. That can be by phone, it doesn't need to be in person, but just make sure you're sort of keeping your panel together. Okay. Once we set the hearing date, we are stating that we won't give any postponements unless there's an emergency situation. We need to maintain the integrity of going forward with these arbitrations so that if something comes up and you cannot attend, if there's enough time and you give us advance notice, we can try to replace the person on the panel. One problem with that is because we then need to conflict screen that person, we need to have at least 10 days to do that. If it's a last-minute situation, we have put in a provision that the arbitration can proceed with the other two arbitrators, but the parties have to agree to that. So it may be that if you can't show up for some reason and the arbitration doesn't go forward because one of the parties wants the three arbitrators, that the arbitration will get rescheduled, and we may just need to schedule it on a date that you're not available. So we're really asking that you make the commitment to the date seriously and that you keep it so that we don't have to go back to the court, get a new order, and set a new hearing schedule. Now, I mentioned that the arbitration can proceed in the absence of one arbitrator if the other parties agree. It can proceed in the absence of a party as well. The parties are informed that they should attend these, that they should definitely attend these. But if we give notice to the party and we think they're coming and they don't show up, the arbitration will still proceed. So just know that there may be times when you're hearing an arbitration that looks a little unusual because you're reading the briefs for both sides, but you may only have one party in attendance. The procedures for this are set out in the arbitration agreement that's in here, which you should look at, but in general know that the rules of evidence are not applying in this case, but the panel, primarily the chair of the panel, will look at the relevance of evidence and the materiality of evidence, so that if evidence is presented, you as the panel have the ability to say that it's just not relevant evidence or it's just not material evidence. But the formal rules of evidence are not applying here. I know that's different than some of the arbitrations that you may hear. We did include a provision in paragraph 11 that if you feel you're unable to make an award based on what you hear on the day of the hearing, you can continue the decision and request more material. We're asking that you do that very sparingly. I don't think this will happen in most cases. You should have everything you need, but we've left you the ability to, if there is just something you need to take a look at and it's not there and you don't feel you can make a decision, you do have the ability to tell the parties that you need to get that document to make a decision, and you won't make a decision until you have it. We ask that you use that sparingly, but know that if there's just something clearly missing, you have the power to request it. Okay. In terms of the award itself, the award should be issued by majority vote so that it can be a 2-to-1 decision. It doesn't have to be unanimous. As I said, we ask that you attempt to meet with your fellow arbitrators and make that decision right away. You will have a form that you'll fill out that we prepare that's just a basic form that states what the award is, what the amount is, who the finding is in favor of. We ask that you sign that if you can that day. There will be lines at the bottom so that if someone dissents and it's a 2-to-1 decision, you as the arbitrator can put that you're a dissenting arbitrator. Once that's issued and you give a copy of that to us, we will then pass that along to the parties. You don't need to notify the parties. So we will send that to them. That they then have the obligation to turn that into the court, which will turn it into a final order. Once we receive that from you, we sort of know that your piece of the case is over, and we then mail each of you your arbitration check. As I mentioned, we really do ask that you maintain the confidentiality of these proceedings, and we've also included a provision that protects you as the arbitrator. You will not be called into any court proceeding to testify about the arbitration. You cannot be called into any proceeding that involves a dispute between the parties. So you should feel free to ask the questions you need to ask and decide these cases without worrying about that. We also ask that after you conclude the arbitration, that you fill out the forms that we've included at the end, the one that's directed to the arbitrators. We really do need to hear from you about how this went for you, what worked, what didn't, what you needed to know that you didn't know, if there was some difficulty that arose at the arbitration, what it was. We want to make sure your next experience is better if there was a problem. So make sure that you do those and get those back to us here so that we can make some changes. Okay. So that's kind of the run-through of the arbitration piece of the procedures. I'm going to hold our questions till the end because some of what I covered is also going to be covered again and your questions may get answered. And I want to turn now to Brad, who's going to speak to those of you who are doing the mediations. The procedure is going to be a little bit different, so Brad's just going to speak a little bit to that.
Thank you, Linda. And I want to thank all of you for being part of the dispute resolution process. Most of you here are here for arbitration training, and we are, from the Center for Conflict Resolution, our volunteer mediators are really just tagging along. And I'm going to save a lot of time in terms of our process and procedures because our mediators, for the most part, know how that's going to work. But I wanted to address a couple things in particular for our mediators so they know what to be looking for during today's session in the arbitration training. and also let the arbitrators who are here just to arbitrate know briefly, in just a couple sentences, what the center does, so you know the alternative that the parties have in making a decision when they go to arbitration. So let me start with that. Actually, let me tell you briefly about the Center for all of you who have not been part of the Center for Conflict Resolution. It actually was established in 1979 by the Young Lawyers Section, and we've been, in almost those 20 years, we've mediated over 17,000 cases. Last year, 2,600, most of them court-referred. And the court asked us to become involved in the mediation side of the fee petitions in matrimonial cases, and we were happy to participate in that process. The other aspect that we do a lot of is mediation training, and the people who will be doing the mediations of the fee disputes are volunteer mediators who have gone through a 36-hour training and been certified by the center that they meet our standard of competence, which every day is getting harder and harder. And so they really are qualified to mediate the cases, and then they have to go through additional training, this being part one of the training that our mediators will have to go through for this specific program. In terms of the process and procedures here, there are a couple that our mediators should be aware of, so I'm really going to be just addressing those in the audience who are already a CCR volunteer. There will be a court order also that the parties, because the parties will have agreed to the mediation process, that the judge will order, and there also will be an agreement to mediate that the parties will sign, and similar information will be provided to the mediator in terms of the petition and other belongings. But from the mediator's standpoint, you don't have to worry about it. It's going to work similar to any other CCR case. You're going to sign up for a time. The parties are going to have particular times to sign up for a CCR mediation that are going to be held at our offices at 11 East Adams, Suite 500. And any of the specific procedures, you will be briefed by a manager of mediation services before and after, just like any other case. And as we proceed, as we probably spend the first month in the program, we will all get together and adapt to this particular program. There is some information on the mediation side in your materials. The General Order, Section 6, gives a brief description of the mediation process. It will be a maximum of 2 hours, for example. And any of that information we can go over at the center as a staff. So I don't want to take up the time here to do that. The reason why you're here on the mediator side is that these gentlemen are very familiar with fee disputes, the law on fee disputes, and the arbitration process. And I want the mediators to be listening to the substantive information, because they know it better than we do, so that when you mediate, and again, for those of you who are not mediators and are new to the mediation world, it's simply an assisted negotiation among the parties in a conflict. So our mediators are not going to be making any decisions for the parties, and for the most part have the ability to help the parties reach an agreement without putting any suggestions out there, and the parties are able to do that. So I would like the mediators to be listening to the substance of what's going to be said after I'm done, so that you can ask better reality testing questions, you can explore the BATNA, you know the procedures, how long is it going to take if they don't reach an agreement to go through the process, how much it would cost, all the typical questions you might be asking as a mediator that the speakers after me can provide you some of that information. In terms of any specific procedural questions that you have pertaining to the mediation side, we are very interested in knowing what those questions are, but I don't want to take up the arbitration training time for that. So if you could let me know, contact me privately, and we are going to have a follow-up training on this, and we can deal with all the specifics. Other than that, I want to thank everyone that was putting together the arbitration program for having our mediators participate today so that they can be more informed. Thank you.
Thanks, Brad. Brad mentioned two things that made me realize there were two pieces of your material I didn't go over. One is the attachment that you got at the end is the general order, which Judge Evans has entered and will address today. The other is your index indicates that you have the AAA brochure on arbitration. You don't. We're actually giving that out next Monday. If you're not coming to that training, you'll get it when